Hello everyone, and welcome to this talk about non-delegable duties of care. The buck stops where? To manage expectations from the very start, I didn't choose this topic because there has been a dramatic and exciting new development in the law. So if that's what you were hoping for, I'm afraid you might be slightly disappointed. I chose it for a different reason. That the phrase non-delegable duties is one that I have come across time and time again in pleadings and in court, but always associated with a vague sense that the lawyers involved, very much including counsel, are not 100% confident that they fully understand the concept of non-delegable duties or its limitations. So what I hope from this talk is that we can have an opportunity to look at non-delegable duties in the round, to give ourselves a thorough grounding in what they are, when they arise, and crucially, when they don't. We can then finish off by looking at how those concepts were applied by the High Court in the relatively recent case of Car and Brands Transport. Now, first off, let's go right back to basics. What is a non-delegable duty? Well, as you'll all know, the usual position in tort is that if I owe a duty of care, but I engage an independent contractor to carry that function out, I am not liable for any harm caused by their negligence in doing so. In other words, I am free to delegate both performance of the task and, with it, the responsibility for performing it properly. A non-delegable duty is an exception to this usual rule. I, as a duty ower, can still delegate performance, but I cannot delegate responsibility. Whatever I do and whatever arrangements I might enter into, legal responsibility for proper performance of the duty remains squarely with me. Now, the classic example of a non-delegable duty is an employer's responsibilities towards its employees. This is the field that gave birth to the concept of non-delegable duties, and it's probably the area that we're all most familiar with. But just to highlight before we go any further, it's not the only area where non-delegables can be found. They also arise in the care and education of children, as we'll see, in the care of patients by medical institutions, and in some other outlying areas as well, such as ownership of land and use of the highway. Now, those outlying areas are of a slightly iffy status now, so I feel fully justified in ignoring them for the purposes of this talk, but just so you know, they are there. So let's turn now to the leading case in the area, Woodland and Swimming Teachers Association. Now, this is a 2013 case, so it's not new. But the detail of the analysis is routinely used as a tool in cases of all levels, first instance and appeal. And so familiarity with the nuts and bolts of the judgment is really very helpful. As a bit of background, the claimant in Woodland was a 10-year-old schoolgirl who was attending a swimming lesson arranged by her school during school hours at a pool operated by a neighbouring local authority. The swimming teacher and the lifeguard were employed not by the school, but by an independent contractor. Unfortunately, during the lesson, the claimant was found hanging unresponsive in the water, and although she was successfully resuscitated, she had already sustained significant hypoxic brain injuries. A claim on her behalf was brought against, among others, the local authority responsible for her school. It was argued that the school had a non-delegable duty of care in relation to the claimant's safety during the school day, even when she was off-site and under the control of an independent contractor. This case went all the way up to the Supreme Court, and they found in the claimant's favour. They held that while a school's educational functions could be delegated to others, the responsibility in negligence for the performance of those functions could not be. Lord Sumption, in giving a judgment with which the other members of the Supreme Court agreed, distilled 5 characteristics which he felt defined mainstream cases of non-delegable duty. The first of these requirements was that the claimant needs to be especially vulnerable or dependent on the protection of the defendant against the risk of injury. So, for example, if they're a child, or if they're an adult under an organisation's care, a patient, a prisoner, or your classic employee. The second of Lord Sumption's requirements is that there has to be an antecedent relationship between the claimant and the defendant. In other words, there has to be a pre-existing connection between the parties which is independent of the facts of the tort itself. As well as that relationship, it has to have two particular characteristics. It needs to place the claimant in the actual custody or care of the defendant, and from that relationship, it has to be possible to impute the assumption of a positive duty to take steps to prevent harm to the claimant. Now, of course, contrast that to your usual duty of care in tort, merely to refrain from acting in a way that causes damage. If you've established the antecedent relationship and it's got those characteristics, then Lord Sumption's third requirement is that the claimant has to have no control over how the defendant chooses to perform their obligations. They cannot choose to have the defendant fulfil the duty themselves rather than engage a third party, nor can they choose what type of third party is used by the defendant. So, for example, you can't have a pupil telling their school who they want to teach their swimming lesson. They just have to lump it. The fourth of Lord Sumption's requirements is the defendant needs to have delegated some function which is an integral part of the positive duty. And in carrying out that delegated function, the third party must be exercising the defendant's custody or control of the claimant. And then finally, the third party negligence must go to the very core of the function that has been delegated by the defendant. It can't be collateral or merely incidental to that duty. Now, in Woodland itself, the Supreme Court had no hesitation in finding that these criteria were met. The claimant was a child, so she was vulnerable, and during school hours, she was in the school's custody and control. The school had a positive duty founded in statute to teach pupils, including teaching them sports, and to keep them safe while doing so. It was this very teaching function which they had delegated, and that was what gave rise to the negligence. So there was no issue in finding that the school had owed a non-delegable duty and that had been breached. Now we've refamiliarised ourselves with the fundamentals, I want to turn to a handful of situations that at first blush may appear to be examples of breach of non-delegable duty, but on closer inspection are not. First, where the defendant doesn't owe the alleged duty in the first place. Second, where the defendant does owe the relevant duty, but it wasn't delegated. And third, where the claimant was wholly to blame for the defendant being in breach of duty at all. Now, the first of these categories, that the wrongful act is not within the scope of the defendant's duty, is very easily overlooked. But logically, before we can address whether responsibility for fulfilling a duty can be delegated, we first have to identify what it actually is that the defendant is obliged to do. Take, for example, the case of Arms and Nottinghamshire County Council. In this case, the claimant had been taken into local authority care aged 7. She was placed with foster parents where she experienced abuse at their hands. Now, it was common ground between the parties that the local authority had not been negligent in its selection of the claimant's foster parents or in its supervision of them. But nevertheless, the claimant brought a claim against the authority, alleging that it was nevertheless liable for the abuse that she'd suffered on the basis it had a non-delegable duty of care to ensure that care is taken in the upbringing of looked after children. Now, at first sight, this seems to be a plausible non-delegable duty, analogous to the duty of the school owed in Woodland. But the Supreme Court held in this case that there had been no breach of a non-delegable duty of care. Considering the detail of the statutory regime, the court concluded that the local authority was not under any duty to provide day-to-day care to a looked-after child. Its only duty was to arrange, pay and supervise for that care to be provided by someone else. Because of this, the question of whether the local authority's duty could be delegated fell away. It didn't owe a duty in relation to the everyday care of a child, and so the claimant's claim failed before it even got out of the starting blocks. Turning to the second limit to non-delegable duties, this is where the defendant does owe a duty, but on the facts it hasn't delegated its performance to a third party. Now, there are two cases that illustrate this idea and illustrate the tension within it. The first is the case of Cook and Square D. The claimant in Cook was an electronics engineer employed by the defendant company. That company had sent him to a customer site in Saudi Arabia to commission a computer control system. Now, the claimant's work was by its nature sedentary. The control room, which housed the computers he was working on, were nothing out of the ordinary, save that the floor was made up of tiles that could be removed to access the cables underneath. Towards the end of his assignment, the claimant was walking around this control room when he got his foot stuck in a hole formed where someone had taken a tile up but hadn't put it back properly. He injured his leg and sued his company for damages. Now, the non-delegable duty that he sought to rely on here was an employer's obligation to provide a safe place of work to its employees, a classic non-delegable duty. The court found that the employer, the defendant company, had taken no specific steps to ensure that the place of work was safe. There'd been no risk assessment of the client's site, no site visit, and the defendant hadn't obtained any details about the nature of the workplace from the occupier. They had, however, satisfied themselves that the Saudi Arabian occupier and the contractors on the site were reliable and were generally aware of their safety responsibilities. On these facts, the court found that there had been no delegation of the duty of care, and therefore the defendant company couldn't be liable for the occupier's breach. Although the steps the defendant employer had taken to ensure the claimant would be safe in the foreign workplace were very limited, in the circumstances they were sufficient to discharge the burden of reasonable care. And so there was no outstanding or unmet duty that was being delegated. Now, contrast Cook to the case of McDermott and Nash dredging. Here, the non-delegable duty being relied on was that of an employer to provide its employees with a safe system of work. The claimant was sent by his employer, the defendant company, to work as a deckhand on a tugboat owned by and operated by a Dutch third-party company. The claimant's job was to untie the ropes that moored the tug to the dredger. The Dutch captain had put in place a system such that the claimant would untie the two ropes and would then double knock on the roof of the wheelhouse to let the captain know it was safe to move off. But on this occasion, the claimant had only undone one rope and was in the process of untying the other when the captain moved off without waiting for the double knock. The result of this was that the rope the claimant was dealing with moved, got caught around his leg and caused him quite serious injury. Now, as in Cook, the employer in McDermott had done nothing specific to ensure that a safe system of work was in place. It hadn't imposed one itself, nor had it checked the system that the Dutch captain intended to use. Also, as in Cook, there was no evidence that the Dutch company was anything other than generally responsible and aware of its safety responsibilities to employees. However, in this case, the court found that the employer was liable. This was on the basis that they had delegated their obligation to create a safe system of work to the Dutch company, and the Dutch company had spectacularly failed to do so. At first sight, these two cases appear to be involving similar actions or inactions on the part of the employer, but completely different conclusions were drawn by the court. In trying to explain why, I think we can look at two characteristics in particular: the degree of known risk to the claimant, and what more could reasonably be expected of the employer at the point the employee is handed over to the care of a third party. In Cook, the risk of harm to the claimant from the workplace itself was going to be small. It was a sedentary, desk-based job in a normal building with no obvious risks. In that situation, it wouldn't have been reasonable to expect a site visit or extensive questioning of the occupier. It wasn't that the employer was relying on the Saudi Arabian occupier to do something extra, it was that there was nothing extra to be done. In McDermott, however, the claimant had an inherently risky job where the safety of the employee depended on robust procedures being followed. At the point the claimant had been sent onto the third-party ship, there was no safe system of work in place. So there was a significant outstanding task that had to be completed before the defendant's duty could be said to be discharged. By not doing it themselves, the employer had impliedly delegated that to the Dutch company, but they negligently failed to do so. And that negligence could be fairly laid at the defendant's door. Turning to the third area I want to consider. Now, this is the situation where the defendant is arguing that despite owing a non-delegable duty of care, and despite that duty having been delegated and breached, it is still not liable for the harm that eventuated, because the breach only occurred because of the claimant's own actions. Now, in some ways, this is a sneaky inclusion, because it's actually a defence rather than a limit marking the outside bounds of the non-delegable duty concept itself. But as we'll see in Carr and Brands Transport, it arises on very similar facts, so it's worth looking at together. Our touchstone with this defence is the case of Brumda and Motornet Service and Repairs Limited. The defendant company specialised in carrying out MOT inspections, and the company had been established by the claimant, who was its sole director and shareholder. But day-to-day management of the workshop had been delegated to an employee, Mr. Lewis. Now, on the day in question, the claimant was assisting Mr. Lewis with an MOT. This involved him getting on a ramp some 6 feet off the ground, but while he was up there, the compressor failed and the ramp got stuck. Mr. Lewis brought him a ladder, but as the claimant tried to use it to get down, he fell and severed a finger. The claimant then sued the defendant, his own company, for damages. Now, the court found that there had been no proper risk assessment for use of the ramp, and there was no regular service and inspection timetable either. So they had very little hesitation in finding that the defendant company was in breach of its classically non-delegable duties under the provision and use of work equipment regulations. However, the trial judge assessed contributory negligence at 100%, and so didn't award the claimant a penny in actual damages. Now, perhaps unsurprisingly, the claimant appealed against that finding, and the defendant cross-appealed on the basis that the trial judge had been wrong to find the company was primarily liable at all. Faced with this double whammy, the Court of Appeal decided to uphold the decision of the trial judge, but on completely different grounds. The Court of Appeal held that once an employee had established that his injury had been caused by a breach of an enactment which made the employer absolutely liable, in other words, our classic employers' non-delegable duties, they don't need to go further to make out primary liability. However, an employer could have a defence to that primary liability finding if it could show that its breach was coextensive with the claimant's own act or omission. Now, at first sight, this case does not seem to fit well alongside the concept of non-delegable duties. The Court of Appeal was careful in its analysis to try not to damage the concept of a non-delegable duty. They're clear in the judgment that primary liability did attach to the defendant, even though the only fault belonged elsewhere. But the practical effect of the Brumder defence, even if it's not the formal analysis that the Court of Appeal favoured, is that a non-delegable duty can be delegated, but the only person to whom it can be delegated is the claimant themselves. Now, let's bring the threads of our discussion together and consider the case of Carr and Brands Transport, which was heard in the High Court in December 2022. Similarly to the claimant in Brumder, Mr. Carr was the sole director and majority shareholder of the defendant company. He was also, as the High Court found, an employee, although that wasn't accepted by the defendant. The defendant company had purchased a second-hand car transporter which should have been subject to an extensive regime of statutory inspections, including regular inspections under the working at height regulations. The defendant company had engaged an external transport manager, Mr. Sippets, on a freelance basis to ensure that those regulatory obligations were properly met. Now, the judgment in Carr is quite lengthy, but in essence, the court found that Mr. Sippets had been negligent in ensuring that the transporter satisfied the necessary health and safety requirements. Had he taken reasonable care, the court found, it would have been identified that the steel guardrail around the top deck of the transporter had corroded through. As it was, this wasn't picked up, and on what would have been the very first day of paying operations for the company, the guardrail gave way, causing the claimant to fall some 14 feet to the ground and sustain catastrophic injuries. Now, the judgment in Carr is interesting for a number of reasons, but there are two that are especially relevant given our focus today. First, Mr. Justice Knoll's treatment of the 5 Woodland criteria, and second, his consideration of whether the Brumder defence applied. Now, technically, having found that the claimant was an employee of his company, it followed that he was owed the employer's non-delegable duties of care. But for completeness, the court went on to consider each of the Woodland criteria so that they could determine whether, even if they were wrong and he didn't fall into the employee category, whether a non-delegable duty would still have applied. Now, first, Mr. Justice Knowles found that the claimant was vulnerable. Now, that seems to me to be an unusual characterisation. The claimant here was in a position of significant power. He isn't your usual employee. As the sole director and majority shareholder, he really called the shot. But what Mr. Justice Knowles found was his vulnerability was his ignorance. The court highlighted the exceptional statutory requirement for a defendant company to have a suitably qualified transport manager. It was mandatory as a matter of statute for the company to obtain experienced input, and as the claimant didn't have the relevant knowledge himself, he was entirely dependent on the company, albeit acting under his own direction, to source that expertise from elsewhere. And Mr. Justice Knowles did acknowledge quite clearly that if the claimant had had the appropriate experience so he could form his own views on the regulatory requirements, then he may well not have been vulnerable under Woodland. Moving on to the antecedent relationship requirements, The court found that there was obviously a pre-existing relationship between the claimant and the defendant, and that was one into which a positive duty could be imputed. But what Mr. Justice Knowles did not address is the other necessary element of the antecedent relationship that we looked at earlier, that the third party has to exercise the defendant's care, custody or control over the claimant. Again, this is an unusual characterisation of the relationship between a director of a company and one of its contractors, but it was the finding that was made. Moving on to the third Woodland factor, Mr. Justice Knowles found that the claimant had a lack of control over how the defendant company fulfilled its obligations. And for my money, this is the strangest finding of them all. The court relied on the fact that the claimant could not himself perform the role of transport manager because he didn't have the necessary experience. Mr. Justice Knowles therefore found that Mr. Sippets in effect had autonomy as to how the obligations were discharged. Now that's all true, but it doesn't actually answer the third requirement in Woodland as it was framed by Lord Sumption in that case. As you'll recall, the question that the Supreme Court posed in Woodland is not whether the claimant could fulfil the duty themselves, but whether they had control over how the defendant chose to carry out that function. As director, the claimant surely did exercise at least some control, because through his control of the company, he could have engaged someone other than Mr. Sippets to do the job of transport manager whenever he wanted to. Now, the fourth and fifth requirements in Woodland were straightforward in the case of Carr. The duty to ensure that the transporter was maintained in line with statutory requirements was integral to the defendant's duty of care to the claimant, and Mr. Sippets' negligence struck at the very heart of this. So the remainder of the criteria were fulfilled with no difficulty. And overall, the court found that a non-delegable duty of care was owed to the claimant, and that had been breached, so primary liability was established. Mr. Justice Knowles then went on to consider whether the Brumder defence would apply to this finding of primary liability. But considering the facts of the case before him, he decided it didn't. The court did find that the claimant was at fault for the accident. He was aware that some of the inspections needed to happen, but he didn't organise them, or, more pertinently, ensure that Mr. Sippet did. But unlike Brumder, the company's breach of non-delegable duty could not be laid entirely at the claimant's door. Mr. Sippet's negligent actions, or failure to act, also had to be considered. The claimant's own fault, while relevant to the issue of contributory negligence, was only part of the reason the company's duty had been breached. And so the Brumder defence, which would defeat primary liability entirely, wasn't available. So that's it for our whistle-stop tour of non-delegable duties. And I hope, if nothing else, that you feel a little more familiar with what is often a very slippy topic to get hold of. Thank you.